Well, thank you everyone for coming today. A big thank you to Professor Alvaré and to Professor Ross for joining us for this preview of Fulton versus City of Philadelphia. I'm just gonna make a couple of brief announcements, and then I'm gonna hand the mic off to Chris to introduce our speakers and to introduce the case that we're gonna be talking about today. So first of all, I do have one plug. We would love for everyone who is showing up today to join the Federalist Society. Our website, fedsoc.org, allows you to sign up for a student membership. It's $5. You get access to loads of programs you get to go to when they have them in person again, the student symposium, as well as the National Lawyers Convention, which I can tell you is amazing. I met Justice Gorsuch there. It was great. In addition, you're able to get a copy complimentary of the Harvard Journal of Law and Public Policy. We've always had students from George Mason who have edited on there. They're going to be appearing in this year's issue. We've had them in past semesters' issues as well. So that's number one. And then you'll also get all of our great emails. Additionally, I want to thank the groups who are co-sponsoring today. This event is co-sponsored jointly by Scalia Law Federalist Society and George Washington Law Federalist Society as well. We also want to say a big thank you to Thomas More Society and Ben Janicek, who's running that, as well as Family Law Society with Charles de Azagra, who is co-sponsoring as well. One brief note, we did reach out to 2 other student organizations to co-sponsor this event, who unfortunately declined. However, we are very dedicated to making sure that we have civil public debates, and we do have a standing invitation to those organizations, as well as any others, which would like to co-sponsor Federalist Society events with us this semester and next. Now I'm going to hand the microphone off to our 1L representative, Chris Barnywalt, who is going to be introducing our speakers, as well as giving a brief summary of the case so far. Thank you, guys. Oh, sorry, one more thing I should mention, how we're going to be doing this event. So it's going to be 15 minutes first for Professor Ross to speak, and then 20 minutes for Professor Alvaré, and then 5 minutes for Professor Ross. And then I will ask anyone who has questions, please use the question and answer feature at the bottom of your screen. Please do not use the chat. That is a little confusing. Question and answer is the best way to keep track of answers, as well as get them in an orderly fashion. So Chris, go ahead and unmute yourself, and you can go ahead and introduce our speakers.
Thank you, Sydney. Catherine J. Ross is a professor at George Washington University Law School. She specializes in constitutional law with particular emphasis on the First Amendment, family law, and legal and policy issues concerning children. Professor Ross holds a JD and PhD in history from Yale, where she focused her research on programs for indigent children in the 1930s and 40s, child welfare, and foster care and adoption programs. She completed her postdoctoral work on child development and on the faculty of the Yale Child Study Center at Yale Medical School, where she advised children's services programs and the HHS on matters relating to child abuse and neglect. Professor Ross was a visiting scholar at the Harvard School of Education and a member of the School of Social Science at the Institute for Advanced Study at Princeton. Professor Ross has taught as a visiting professor at Boston College and St. John's School of Law in New York and the University of Pennsylvania, where she served as senior legal consultant for the Center for Children's Policy, Practice, and Research. As an attorney, Professor Ross was co-chair of the Presidential Working Group on American Children at Risk under the Clinton administration, and was chair of the ABA's efforts to implement the practices outlined in the group. She has also participated in multiple ABA local and national groups on child welfare. Professor Ross recently published a book on students' First Amendment rights, and she currently teaches constitutional law, family law, and child, family, and state. Helen Alvaré is a professor of law at Antonin Scalia Law School, George Mason University, where she teaches family law, law and religion, and property law. She publishes on matters concerning marriage, parenting, non-marital households, and the First Amendment religion clauses. She is faculty advisor to the law school's Civil Rights Law Journal and the Latino Law Student Association, a member of the Holy See's Dicastery for Laity, Family, and Life, a board member of Catholic Relief Services, a member of the executive committee of the AALS's section on law and religion, and an ABC News consultant. She cooperates with the Permanent Observer Mission of the Holy See to the United Nations as a speaker and a delegate to various United Nations conferences concerning women and the family. In addition to her books and her publications in law reviews and other academic journals, Professor Alvaré publishes regularly in news outlets including the New York Times, the Washington Post, the Huffington Post, and CNN.com. She also speaks at academic and professional conferences in the United States, Europe, Latin America, and Australia. Prior to joining the faculty of Scalia Law, Professor Alvaré taught at the Columbus School of Law at the Catholic University of America, represented the U.S. Conference of Catholic Bishops before legislative bodies, academic audiences, and the media, and was a litigation attorney for the Philadelphia law firm of Stradley, Ronan, Stevens, and Young. Professor Alvaré received her law degree from Cornell University School of Law and her master's degree in systematic theology from the Catholic University of America. And a brief summary of the current case. On the day after the November 3rd presidential election, the justices will hear a challenge to Philadelphia's exclusion of a faith-based agency from its foster care system because the agency will not work with same-sex couples. Catholic Social Services is a religious ministry location in Philadelphia. Among other services, CSS cares for foster children through a system that is partially supported by a contract with the City of Philadelphia. And separately, another function is to research and certify potential adoptive families. Because of its religious beliefs, CSS does not certify same-sex couples. The City of Philadelphia now requires CSS to certify these couples or have their contracts with the city to foster children ended. The first issue in this case is whether free exercise plaintiffs can only succeed by proving a particular type of discrimination claim, namely that the government would allow the same conduct by someone who held different religious views, as 2 circuits have held, or whether courts must consider other evidence that a law is not neutral and generally applicable, as 6 circuits have held. The second is whether Employment Division v. Smith should be revisited. The third is whether the government violates the First Amendment by conditioning a religious agency's ability to participate in the foster care system on taking actions and making statements that directly contradict the agency's religious beliefs.
Thank you very much, Chris. You can mute yourself and turn off your camera. So that was the summary that we mostly pulled from SCOTUS blog. If you would like to read more information about the case. Professor Alvaré, Professor Ross, I'll go ahead and hit your time whenever you're ready. I'll turn my camera back on when your 15 minutes are finished.
Thank you very much, Sydney.
Thank you.
First, thank you for that nice introduction and summary, Chris, and thank you, Sydney, and the other organizers for putting this important event together. And I'm really glad that this is a collaboration between our 2 law schools. Fulton raises very important questions that were correctly decided below. If the court should elect to re-examine Smith, I would argue that this is not the right vehicle, both because of its procedural posture and its facts. I would urge the court to think about whether cert was providently granted. The procedural posture of this case is that the district court denied a motion for preliminary injunction, and the Third Circuit unanimously affirmed. A 3-day hearing was held in the lower court, but there was no discovery, there is no full record, and there are complex facts, many of which remain disputed, and some that are not disputed are still the subject of dispute over their constitutional significance. The Third Circuit found, as had the district court, that the appellants were not likely to prevail on the merits under the preliminary injunction standards, and that they did not satisfy a single other prong of the preliminary injunction inquiry. So I would suggest that if the court is inclined to rule for Catholic Services, it consider vacating and remanding for fuller development of the facts. When we look at other Supreme Court decisions that arise in this kind of posture, the holdings are often muddled, are harder to apply, and sometimes the only thing that comes out of several fractured opinions is that the case needs to be remanded. So I would suggest that we avoid that kind of precedent that may well end up causing more confusion than it succeeds in resolving problems. So the facts are also not ideal for reconsidering Smith. Here we have a private agency fulfilling what is clearly a government function. It is delegated authority to represent the state, and for those activities, it is significantly funded by the state. I want to say a few words about the history of child welfare here. Historically in the United States, as in England, voluntary agencies, many with a religious bent, though not all of them, were the sole source of child welfare. They took care of neglected and abused children, orphaned children, children who simply were very poor, whose families couldn't take care of them. Private agencies like the Society for the Prevention of Child Cruelty had power to go into a household and remove the children and place them in a congregate care facility or send them out through an agency to work on a farm. And these were the programs that ultimately became our child welfare system and our foster care and adoption system. When the state finally acknowledged its parents patriae responsibilities, the state took over these functions exclusively, but it continued to contract out some of the performance to private agencies, including religious agencies. Today, the children are not the wards of private agencies, they are the wards of the state. And it is not possible in Philadelphia for Catholic services to work with children who are going into the foster care system or the adoptive system, except by license from the state and through these contracts that it has with the city. So we have a system of enormous regulation from the federal, state, and city government, and delegation of powers that cannot be exercised absent that express delegation. And here, as I said, the Catholic Services receives significant funding, not just for its work in placing children in private homes, but for its congregate care facilities and its community service structures that also serve children in private families. The Catholic Services argue that they cannot be regarded as an agent of the state. And as I understand it, they make that argument based on a phrase in the contract that, if you look at it, is clearly intended to absolve the city of tort liability. You cannot say that the agency is operating as anything other than a government contractor fulfilling a public function. So this is even different from a government contractor who is, hired to build a facility for the government, which might or might not be considered a government function. They are doing something that only the government has authority to do. And I would argue that Catholic Services asks the Supreme Court to reconsider Smith and to overturn it because they recognize that they lose under Smith. That standard will not get them where they want to go. And the Third Circuit analyzed the case both under the ruling doctrine today, Smith, and under the Pennsylvania RIF-PA, as it is, because it's a Protection Act, which is essentially strict scrutiny, and found that Catholic Services was not likely to prevail under either analysis. So let me first very briefly get rid of the speech claims, because I think they're non-starters. Compelled speech. Catholic Services isn't required to say anything to anybody. It argues that it is compelled to use words and to express approval of non-marital couples, or couples it regards as unmarried, as well as couples who actually aren't married, by certifying them as acceptable, competent caretakers for children. But all they need to say is that we applied the factors set out by the state, and we find that this family satisfies those standards as the state defines them. And the city has even said you can express your agreement right on the form, that this should not be construed as approval of these marriages, or we expressly, our church does not recognize same-sex marriages as legal marriages, though we understand that the state of Pennsylvania does. But they're not willing to do that. The second speech claim is retaliation claim, but because they're government contractors, that's governed by Garcetti, and all of the communications about these families and the certification are in the scope of their work for the state or for the city. So both of those really are very weak claims. And I think they were thrown in to try to reach a hybrid claim under Smith. And the status of those hybrid claims is highly unclear. The circuits are divided about whether to apply the hybrid claim at all, and if so, what standard applies. And the Third Circuit has not taken. So now I want to turn to the Pennsylvania RIPA for exercise claims, under which the plaintiff must show by clear and convincing evidence that there's a substantial burden and that it's imposed on a fundamental belief. And that's the law in Pennsylvania under Ridley Park. And I understand that should the Supreme Court decide it wants to reverse Smith, it may well have a different definition. So to find out whether the activity is fundamental in Pennsylvania, the court needs to ask whether the activity is inherently religious or could it be performed by a secular group? And there are several ways to frame that question. Is it about caring for vulnerable children? I think the answer is clearly a secular group can do that, and secular groups do that. Is it about certifying foster parents and placing children in private homes? Again, secular groups can do that, and they do that. Or are they arguing that it's fundamental to the faith not to certify that a person qualifies under the state code as a competent parent? The Catholic services need to explain exactly how it violates Catholic faith to certify that applicants qualify to be foster or adoptive parents under the state's statutory factors. And as I said, they can add a disclaimer. And they must show how their exercise is burdened by doing a home visit, filling out a form with a disclaimer, we applied the state's criteria, we do not necessarily agree with those criteria. The court is, the city and the court are not asking that Catholic services either recognize the marriages they find offensive to the doctrine, or that the church perform marriage ceremonies. In fact, every state has an express disclaimer in their family law statutes saying that no religious group shall be forced to perform a marriage that is in conflict with their doctrine. And that has become, of course, much more important since Obergefell. So what are the compelling interests? That is not a complicated inquiry here, because eradicating discrimination, as Chief Justice Roberts has pointed out, is always a compelling interest. And here the goal is to reduce to zero the number of discriminatory agencies working for the city, standing in the city's stead. And when you're an applicant to become a foster care parent or an adoptive parent, you don't always really, you know this is a city function. It's been doled out to 30 private agencies. And you don't really know whether discrimination is because of the city or because of the agency. Although I will note that communities of people tend to talk to each other. And so it's not surprising that not a great many LGBTQ couples present themselves to Catholic services in the record. They know they're not going to get approved, they're not going to be served there. And the CSS also has other services it continues to offer under contract with the city, congregant care and services in the community, from which they receive all but $2 million of the city funds that they had been receiving prior to the expiration of the contract for foster care placements, and therefore that really undercuts their claim that there is animus or discrimination. So when we really look at it, Catholic Services is asserting a positive right to be treated better than non-religious agencies, or than other religious groups that have different views, or than other religious groups with similar views who have agreed to compromise with the city so that they can continue doing this extremely important work. So it is more than a request for an exemption that doesn't affect anyone else. There is no property right to a contract or a renewal of a contract. There's no right to government funding under a contract. There's no right, as I've said, to freelance in the areas of foster care and adoption because they are a government function and heavily regulated. It is not the insistence on obeying the law and also fulfilling the contract terms, which say very clearly you have to obey the anti-discrimination law. And the city, one of the disputes is whether in any new contract, the city can make it even clearer that the non-discrimination law applies to these contractors so that there will not be any future misunderstanding. And Catholic Services says, no, we're entitled to the contract we used to have and to exemption from the non-discrimination policy. But if you look at the facts, there is no targeting at all because of religious belief. And if it's targeted at all, it is not on the grounds of being a religious entity as required under Espinoza and Trinity Lutheran, where, by the way, the playground was open to all, but for not obeying the law and not fulfilling the contract terms. That's not a targeting based on being a religious entity or even based on religious views. This is views and conduct, which ever since Reynolds have been distinguished and continued to be distinguished in Smith. This case looks more like Kim Davis, the county clerk who would not grant marriage licenses to same-sex couples after Obergefell. And
Professor Ross, I'm sorry to interrupt, but if we could have you conclude.
Yes.
Thank you.
1 second. So yesterday, as you all know, I'm sure you know, the court denied cert in the Davis case. And I grant there were two strenuous dissents wanting to overturn Obergefell, but for now the law is what it is. And basically, if your personal beliefs say that you cannot fulfill the essential requirements of your government job or hear your government contract, then you should do something else. You cannot take a job where you are fulfilling government policy and say, I won't do that policy because I don't believe in it.
Thank you for speaking, Professor Ross. Professor Alvaré.
Thanks so much. And thank you, Catherine, for an excellent presentation that really shows your deep store of expertise in this. This case, I think, is really hard for us to convey in a brief presentation. It mixes everything from religious freedom, free speech, non-discrimination, foster care, and it's very factually complex too, as I think Catherine's right to point out. Because I teach at Scalia Law, I thought I would begin for students who haven't had con law with the briefest primer on the Byzantine ways of the First Amendment with a broad brush at 3,000 feet and 100 miles per hour. So before 1990, the Supreme Court would respond to even a neutral, generally applicable law, like send your kids to a school by, till a certain age, that happened to burden a religion, like it burdened the Amish who wanted their kids home for various teaching purposes. The Supreme Court would respond to that law with strict scrutiny. That is, did the state have a compelling state interest realized by means least restrictive of religion? After the Smith case, however, the Supreme Court said in 1990, hey, if a neutral, generally applicable law burdens religion, even badly, the law can stand if a state has merely a rational reason, a rational relationship to a legitimate state interest. In 1993, President Clinton, a nearly unanimous Congress, the ACLU, the US Catholic bishops all get together and pass a law restoring the pre-Smith standards. So to provide really serious protection for religious freedom, it's called the Religious Freedom Restoration Act, or RFRA. Now, it only covers federal laws. So a bunch of states then decided to pass their own religious freedom restoration acts, or to interpret their constitutions to be very religious protective. So you can see it's kind of a patchwork. Since the passage of RFRA at the federal level, the Supreme Court has spoken several times about the free exercise of religion. So let me lay this out for you briefly. First, the Smith case does not apply this low, very state deferential standard to a law if a state demonstrates outright hostility to a religion, whether this is in a law, a reg, or an administrative adjudication. If the state does this, its policy is just going to be struck down as not neutral toward religion. This was the Masterpiece Cake opinion. This is also an opinion called Lukumi. In Masterpiece Cake Shop, you not only had 5 members of the court, you had 7 members of the court, including Breyer and Kagan, come down this way. Second, said the Supreme Court, not only is the state forbidden to outright prohibit a religious practice, but it can't indirectly coerce or penalize religion. This coercion includes the refusal to allow a religious organization to compete with secular organizations for a grant. It doesn't mean the religious organization is entitled to a state grant. It means they're entitled to compete for a grant if they are otherwise eligible to receive it. This would be an unconstitutional condition if the religion had to, speak or act differently from its religion in order to get the grant. The government can't force a religious organization to speak against its will, against its religious beliefs as a condition for a grant. Third, from the Supreme Court, laws are not neutral and generally applicable if they give secular exemptions, but refuse to grant religious ones. This is the Lukumi case. Or if the relevant legislative or regulatory body handling the law or policy really demonstrates hostility to religion, then it's not a neutral government act. Or if the state has retained a lot of power to dole out individual exemptions, but it won't give an exemption to the religious group, okay? If a law is not neutral or generally applicable like this, then the law is subject to the pre-Smith standard or the RFRA standard, compelling state interest, least restrictive means. And as pointed out in the introduction here, 2 lower courts, including the Third Circuit in this case, have proposed a much more stringent test for whether a law is neutral or generally applicable. Did the state refuse to work with another agency that had a different religious policy on this matter? In this case, it's referring out to same-sex couples. 6 circuits have said that the various standards that I've just taken from Masterpiece Cake and Lukumi as to when a law is not neutral or generally applicable are rather the appropriate standards. Now, this brings me to the Fulton case. We are watching eagerly to see whether the Supreme Court is just going to apply the Smith standard. Is it going to find an unconstitutional condition on the part of Philadelphia? Is it going to further clarify what makes a law not neutral or generally applicable? Or is it going to get rid of the Smith standard? All of these things are in front of us. It's going to be a super interesting case when it comes out. Now, let me address Fulton directly in 3 points. On its face, it's really easy right away to see this case as asking, why shouldn't a city be able to reject a contractor in a city program who doesn't agree with the city's thoughts about what is appropriate sexual expression? The city can do what it likes with its money and programs, right? But it's far more complicated than this. The first thing I'll mention is a matter of policy, and the second 2 are matters of law. The first, a policy matter. Adoption and foster care services were really meant to give a suitable home to children in need. They're not about answering adults' desires for children. That latter position, as Professor Ross has sort of generally indicated, was the bad old days of adoption and foster care. Children were given to adults who wanted them, and in that time they were used for labor of various kinds. Modern and contemporary law, though, wanted to flip that paradigm back and say that it's about children's needs coming first. But Philadelphia here has banished one of the oldest and notably most effective agencies, Catholic Social Services, CSS, with a list of waiting certified foster parents. Though Philadelphia admitted 2 days after it cut CSS off that it had a foster placement crisis. It had 300 kids in institutions it would like to put in families, but refused to use the families that CSS had waiting and certified. It chose to have fewer foster kids placed because it's siding with adult interests. A dozen other jurisdictions nearly have allowed religious foster care agencies to be just one of the number of agencies in the city's pool. Philadelphia's Catholic Social Services is waiting and ready to refer same-sex couples to other agencies, happily. Not a single same-sex couple will be denied, if they get certified by another agency, their access to a child. But Philadelphia won't even allow CSS to do that. Now on to the law. Philadelphia does have, as Professor Ross indicated in describing this as a government program, government authority over the children, government parents patriae. Philadelphia has a monopoly, in a sense, on foster care. They control the fate of the children taken into the system. No foster agency privately will have the opportunity to receive a child, to give that child to a waiting foster family, unless Philadelphia will refer a child to it. In this situation, isn't a refusal to work with a religious agency that won't bow to Philadelphia's own beliefs about sexual expression an unconstitutional condition, a burden both on religious freedom and speech? Philadelphia refuses to even allow CSS to be a contractor unless it acts against its religious beliefs or is forced to speak against its beliefs by writing home studies and certifications in favor of foster situations it religiously opposes. Now, here's where Professor Ross's statement comes in that, well, Philadelphia says, CSS, you're just an agent of the city. You're speaking with our mouth. There's a couple of problems to that. And it's in addition to the fact that the contract itself says you are not an agent, you are not an employee. And it's not only for purposes of no tort liability, it's for general purposes. It says you are an independent contractor. Second, the services that the city contracts for do not involve the interviewing, home studies, and certification of any family for foster care. It is not Philadelphia's relationship with any of the private agencies. It's not Philadelphia's dollars. It's their own dollars that they use to receive families who are interested, do home studies, write a certification. Professor Ross's suggestion that Philadelphia could certify families that oppose their religious beliefs and simply say, we don't believe that this is the right thing, is like exactly what the Supreme Court declared wrong in the Barnett case, where people had suggested that Jehovah's Witnesses kids who didn't want to salute the flag could say, all right, you can force me to stand and salute the flag and say the Pledge of Allegiance, as long as I can tell people later I don't believe in it. No, you can't force speech as long just under the circumstances that you allow someone to say the government made me say it. Okay. Philadelphia also argues that it's just only setting terms to be a government contractor. But again, Philadelphia does not cover or pay for the services that it objects to, that CSS objects to, doing the home studies, certifying particular people against its religious beliefs as suitable foster parents. The city admits it has, quote, unquote, nothing to do, unquote, with home studies. That's the state controls the content of them. The city is unrelated to those. It is not funding CSS for those. They rather want to condition allowing CSS to be a, to compete for this kind of contract, enforcing CSS with its own resources to speak and act against its religion by doing home studies and certifications against its beliefs. If Philadelphia were to prevail in this case, it really does make you wonder what would come next. I mean, the government has asserted more and more and more almost monopoly power over education. They have a tremendous amount of power in healthcare. They decide to recognize marriages. Will we be in a position where they can say, I don't care how many poor children you serve, and Catholic schools in particular serve a disproportionate number. I don't care how many nonprofit hospitals you have serving the poor, and Catholic hospitals are number one in this among nonprofit hospitals. None of you, neither Catholic, nor evangelical, nor Orthodox Jewish, nor Muslim, can participate at all in the public square in areas where the government really has the last word if we don't agree with your religious positions on these hot button social issues. Third and final point, if the state is overtly hostile to a religion or willing to grant itself and others all kinds of secular exceptions from a law or policy that burdens religion, shouldn't the court either strike that law down as overtly hostile and therefore not in conformity with the First Amendment, a la the Masterpiece Cake Shop case, or at least take a really hard look, apply strict scrutiny to the law because it's neither neutral nor generally applicable? The evidence of Philly's hostility to the Catholic services, the Archdiocese, the Church, is legion. I am a Philly girl. I have about 135 families still living in or around Philadelphia. The mayor is a very virulent ex-Catholic who the Philadelphia Magazine, a very liberal magazine in accordance with the mayor's own views, has written an article about calling Mayor Kenny's long war with the Archdiocese. He has begged Pope Francis to come to the United States and, quote, kick some butt in the Philadelphia diocese. He has publicly tweeted that he, quote, couldn't care less about the people in the Catholic Archdiocese of Philadelphia. This city government tone that Kenny has set for years and years, dozens of public statements against the church, was really manifest in the process for kicking CSS out of the foster care pool. First of all, his administration instigated a full hearing into CSS, even though it requires a complaint with notice to the person you're having a hearing about. There's never been a complaint about CSS. They've never had a same-sex couple approach them, but there's never been a complaint about them on this issue. He gave them no notice of a hearing, calls them in. At that hearing, there were all kinds of hostile comments made, such as they were using religious freedom as a guise for discrimination. They should get with the times. The city told Catholic Social Services they didn't understand their own religion and that the city could better interpret what Pope Francis was thinking, and the city should go along, or the Catholic Social Services should go along with the city's interpretation. I am trying to imagine another religion being put under this kind of pressure with these kind of statements being made, that you want their butt kicked, you know their religion better than they do. Very hostile stuff in the course of kicking CSS out. In the Masterpiece Cake Shop opinion, 7 justices on the US Supreme Court said that overt hostility, a lack of neutrality quite evident against a particular citizen or group of citizens based on their religion, was itself a violation of the state's duty under the First Amendment. You didn't even have a balancing test. That hostility was simply by itself out of step with the First Amendment. In addition to these comments, we can see hostility elsewhere in other parts of the process of the city's rejection of CSS. We can see in the same events both that the city was overtly hostile and that the policy it's trying to apply is neither neutral nor generally applicable. First, Philadelphia's ever-shifting, after the fact, post hoc cutoff rationales and the many, many exemptions from non-discrimination requirements that it allows itself and other foster agencies, and previously had allowed CSS, but now says are not permissible. First, Philly claimed that CSS violated the law on the public accommodations laws, a fair practice ordinance, the FPO, which you all know this kind of law. It bans discrimination, race, sex, sexual orientation, age, marital status, etc., in connection with public accommodations. But then the city admitted that it had never applied this law to itself, because the city readily, when it takes a child and goes to one of these agencies and says, okay, you've certified families on your own, now we would like to choose one of them and place a child with you, the city always was looking at factors like race, age, ability, disability, family, and marital status. So they themselves admitted that the Fair Practice Ordinance had never been applied to foster care. Furthermore, foster care is not a public accommodation. It kind of gives me chills the city even made this argument. Foster children are not restaurants or movies or hotels that have to be available to adults who want them. Foster care is not supposed to be about serving adult interests. So the Fair Practice Ordinance went away. The city stopped saying that that was the basis for its argument. So it's not claiming a neutral law of general applicability, this ordinance, anymore. Second, Philadelphia says, oh, we have a contract with CSS that says you cannot refer a child or a set of foster parents that you don't want to handle to another agency. But the city later admitted that this does not apply to any situation except set of foster parents or children that the city sent to an agency, not the agency's own choice of which foster parents to interview. The city also later admitted that referrals happen all the time. One agency refers to another all the time because it has a greater specialty in, say, Hispanic parents or parents who will adopt children with special needs. So the city said, okay, we're relying on contract 3.21, and then they had to say, no, actually referrals are allowed all the time. We don't enforce this against ourselves or others. Then the city claimed that its charter required all city contracts to have a non-discrimination clause, but then it retracted that claim because it turned out that that clause is not applicable to professional services contracts like foster care, because the city itself, in using professional foster care independent contractors, took factors like race, age, disability, family status into account. Finally, after cutting off CSS, the city says, okay, we're just going to make a new contract with you. So our old contract provision doesn't do the job. The Fair Practices Ordinance doesn't do the job. The city charter doesn't do the job that we want, which is to cut you off because you won't certify certain families. We're just going to put a new contract provision into all the contracts that say you cannot discriminate against families who have a couple of same-sex orientation. But then the city admitted that there is a mechanism in that contract requirement so that the city could give individualized exemptions. The Supreme Court has said several times that a system of individualized exemptions, the Sherbert versus Werner case was one of them. Lower courts have said the same thing. A system of individualized exemptions is not a neutral and generally applicable law. It's rather the city picking and choosing who it wants to work with, and the law is not neutral and generally applicable on its face. From all this, I would conclude that it's easy to see that the city is overtly hostile to a religious agency and should lose under Masterpiece Cake. But even if it doesn't win under Masterpiece Cake, and I will finish in under a minute here, the CSS should win because under Smith, we're dealing with a state policy that is very far from neutral or generally applicable. Thus, it should be evaluated according to whether the city has a compelling interest satisfied by least restrictive means. But the state can't possibly show that because even if it could say it had a compelling interest, it could say also that we easily have a least restrictive means of satisfying it. Require CSS, as it already is willing to do, to refer any same-sex couples who come their way, even though none ever have, to one of the several dozen other agencies in Philadelphia that will certify them as foster parents if they qualify. Finally, even if the Supreme Court finds that the Philadelphia policies are neutral and generally applicable, they might choose to revisit Smith, and that's a conversation we can have today or another time. So thank you very much.
Thank you for speaking, Professor Alvaré. Professor Ross, your final 5 minutes. Professor Ross, we can't hear or see you.
I'm sorry. Okay.
No worries.
Here I am. Can we start the clock again?
Yes, of course. Your camera
And
isn't turned on,
my
though.
video is also off. Oh.
Yes, there you go.
Okay, thank you.
Of course.
First, I am, my husband's from Philly. We can talk cheesesteaks another time. So I'm going to only refer to a couple of the specific points and then make a broader social policy point. In terms of the comparison to Barnett, I think Barnett is totally off point, because in Barnett, the children were required to go to school under the compulsory school laws. If they couldn't afford a private school, they could be institutionalized as juvenile delinquents, and their parents could go to prison for violating the compulsory school laws, not at all like a private agency seeking a contract. Secondly, the home studies, it's true, are not compensated specifically, but they are the only way for an agency to get access to the funds for placing and supervising children in foster care, because the city will only send children to the agency for placement to be matched with homes that that agency has certified. So you could regard it as a preliminary submission to qualify for the contract. And there is certainly nothing illegal about that. I think the slippery slope is, also very distinguishable, because in all of those systems like education and health, we have long had a system that had a combination of private and public services that people could choose among. And going back as far as Meyer and Pierce, the early substantive due process cases in Liberty, the court said expressly in both cases, there is no question here that there's a right to use a private education agency. They do have to be certified by the state to the extent that they meet certain minimal requirements. But I don't think that that's at all comparable to a situation that is completely controlled by the state, like foster care and adoption. So as to the broader issue and why referrals out won't work, this problem is not a zero-sum game. Recognizing Catholic Services' claim will impinge on other people's dignitary rights and, to some extent, their civil rights. You're not just denying services to same-sex couples, you're hurting families that are already headed by LGBTQ parents. These interests for the children, not the parents, were front and center when the state and federal courts considered challenges to the bar on same-sex marriage in the period leading up to Obergefell, and Justice Kennedy also recognized it. Their children are being told that the state views them and their family as second-class citizens, something that conservative and eminent jurist Richard Posner discussed at some length in Vasquez versus Bogan in 2014. He says, homosexuals, the older term that he used, are major sources of adoptive homes. And they're more likely to adopt foster children than opposite sex couples. And the more willing adopters there are, the fewer abortions there will be, he said. Carrying a baby to term and putting the baby up for adoption is an alternative to abortion. And he says the pro-life community recognizes this. And he says there's harm to children. Suppose a child comes home from school one day and reports to his parents that his classmates have a mom and a dad, and he has two moms or two dads. Children, being natural conformists, tend to be upset upon discovering that they're not in step with their peers. Now you might say, how does that apply to letting one agency out of approving same-sex couples? Well, if Catholic Services succeeds, then children in Philadelphia who are in same-sex households, parental same-sex households, whether in foster care or not, they're likely to learn that there is an agency certified by the city performing a public function that regards their parents as less than the parents who are heterosexuals, and that would have exactly the harmful effects that Posner and other federal judges feared. Also, in the meantime, countless couples have relied on Obergefell forming these families. And so the ramifications, I agree with Professor Alvaré, have affect many areas of both law and life, and the decision below should be affirmed.
Thank you for speaking, Professor Ross. We're going to move on to our questions now. So if both of you would like to unmute your microphones. All right. The first question, This is for Professor Ross. At the beginning, you mentioned remanding for further inquiry into the particular facts surrounding this case. What types of facts do you expect may not be reflected by the record, and how would those facts change the relative ease or difficulty of how this case is decided on the law?
Okay, excellent question. And I want to refer to Professor Alvarez's excellent presentation and her command of this record. She talked about a lot of things that happened actually after the Third Circuit opinion and during the process of this litigation. Some of the arguments that were waived, and there were arguments actually waived on both sides that I didn't go into. So one thing is, what is the rest of the record shows us? Because these negotiations have continued and the postures have been adjusted. So we need to understand that. This was a preliminary injunction investigation. We didn't have discovery. A lot of the things that are stated in the record, which for purposes of preliminary injunction are, given some credence, are contested. So the city says, we've never granted an exemption from this aspect of anti-discrimination law. Race is easily distinguishable, as the Third Circuit held, because there's a long history in federal policy about foster care that there's some consideration given to certain kinds of racial and ethnic matching, like under the Indian Child Welfare Act, and giving some consideration to placing children of color with parents of color, as long as that doesn't mean they fall behind in line for family. So I would argue that that is not remotely comparable. And even in terms of some of the incidents of the mayor, there are questions about whether he exercised any authority at all in this decision-making process. I don't know enough, and I'm not here to defend his statements. I didn't even know that he was a lapsed Catholic, because the record doesn't say that. It says he's a Catholic, but that's beside the point. There are a lot of things like that, that in a constitutional area like this, where the facts are so specific, and we call them constitutional facts that need to be placed in context, we just don't know enough about the complexities of this case.
Thank you, Professor Ross. The next question is for both professors. The comparison between this case and yesterday's case on Kim Davis does some particularly poignant work for this discussion. At the most granular level of description, it seems like these cases highlight a clear conflict between the constitutional right to freely exercise religion from the First Amendment and the constitutional right to same-sex marriage and related rights from Obergefell. Does the fact that multiple cases where this apparent conflict of rights exists indicate that the court should take a step somewhat like Davis, simply to clarify the scope and take a case somewhat like Davis, simply to clarify the scope and parameters of the conflicting rights?
I'll be quick, so Professor Ross could also jump in on this one. Everybody was left frustrated after Masterpiece Cake. We're still waiting to hear about Arlene's flowers and the photographers and everything about what the court is really going to say when we have a question of even a neutral and generally applicable law, whether it is or it is not, whether there's some hostility behind it, and a question of a same-sex marriage and a unwillingness to express an agreement with it or cooperate with celebrating one. We don't have a lot of clues from Masterpiece Cake. Justice Kennedy, who's no longer on the court, talks a great deal about the necessity of recognizing the absolutely equal dignity of LGBT persons. At the same time, he makes an interesting comment, which actually goes to something Professor Ross said a minute ago. He goes, listen, everybody knows certain churches do not celebrate same-sex marriages. It's well known. And he goes, I'm not going to, he makes a comment, it's not, it's dicta, but he says, this isn't going to hurt anybody's dignity, that everybody knows that this church, this one, and this one will not celebrate same-sex marriages. People grow up in a society with different opinions, whether they're children or adults, they come to understand that. We all have our dignity, taken on in really strong ways in this the questions comes up is, well, is the fact that there is an agency that everybody knows is Catholic and everyone knows where they stand on various positions on marriage is not going to go along with this? Is that going to be more like Justice Kennedy's opinion that, yeah, we can work with this kind of religious disagreement in society? Or is it going to be that offending someone's dignity and the state preventing that is so compelling that it overcomes burdens on religious freedom? I'd love to see a case that brings all this together and settles it.
That's a really important point about the range of churches and their beliefs and the services that they provide. But I don't think it's comparable to what we're talking about here, because the churches are operating purely as religious organizations. They are not purporting to fulfill any sort of public function. Of course, you can, I believe, walk into any church during a service. They don't ask you if you subscribe to their religion, but you have no expectation when you do that they're under any compulsion or even moral obligation to treat all comers the same way for purposes of their services, which I would include the marriage ceremony, which is not necessary because you can get civil certification of a marriage. You don't need a church in the same way that you need a clerk to give you a marriage license or a pharmacist to fill your prescription. This is not limited to the rights of LGBTQs. This same thing comes up with pharmacists with morning after pills and even with birth control. And pharmacists are licensed, so we could make this an even bigger problem. I agree that it would be wonderful for the court to consider this question because it's a recurring one. But I don't know that it would resolve this case in a very helpful way.
Thank you both for your answers. This question is for Professor Alvaré. If Philadelphia stopped granting exceptions for other anti-discrimination rules regarding childcare certification, do you think this new contract would no longer violate Masterpiece and thus be allowed?
Okay, so couple questions. They're not going to stop granting exceptions because it's in the nature of foster care placements to do really close personal evaluation of families for all kinds of compatibilities with a child. It's not going to resolve the question of the hostility shown in this particular case. And I think it doesn't solve the larger problem. Professor Ross was talking about, there's all kinds of public functions, and she's talking about public functions that the claim is that the CSS is serving here, but solemnizing, allowing our clergy to have a state recognized solemnization, educating children and having the state recognize that child as having been to school, taking Medicaid patients and having the state recognize that the religious hospital is doing what Medicaid requires. I still think we're in a world of hurt, mostly for poor and others who are being served by these nonprofit social services provided by religions. If we say that when you are a contractor with the state, you have to mouth and act out the state's religious positions. So I don't think it would just be enough to have that one change in the contract.
Thank you. This is another question for both professors. Espinoza and Trinity Lutheran established that it was impermissible for government to discriminate against religious groups on basis of religious status, but governments could discriminate if the religious group may use public funds for religious purposes. But both the dissent and Gorsuch's concurrence argued the purpose/status distinction is muddy. How do you think the court in Fulton may clarify this distinction?
Go first.
Okay, so yeah, this is really, really interesting, this status conduct thing. And it's interesting on two sides. One, sometimes when religious agencies say, I'm not discriminating against someone based on their status, but on their conduct. So we hire single, married, divorced, widowed people. We just are not going to cooperate by facilitating cohabitation or a same-sex marriage. Therefore, we're not discriminating based on sexual orientation or marital status. We're discriminating based on people's choice of certain conduct. That's one side where it's confused. The other one is the Justice Gorsuch concurrence in Espinoza, where he says, and in Trinity Lutheran, he asks the same question. Are we saying that the government is not able to discriminate against people based on their religious status? That is, Trinity Lutheran is a religious entity, you can't get a grant. Religious school in Montana is a religious school, you can't have the benefit of the tax deduction in the vouchers or the tax credit in the vouchers. He says, to me, if you're forbidding money to go to a place because they engage in religious conduct, it's the same as just discriminating against them based on their status as religious. I do not see an appetite on the court's part to settle that question right away, or in this case. I don't know if Professor Ross agrees with me. That is a really complicated question. It involves Locke v. Davey, where the court said that a state could make this sort of subtly disfavoring religion slightly by not funding certain kinds of degrees. That is, the degrees that lead to being a religious minister, because we have this huge historic tradition of not taxing folks in order to pay for ministers. I just don't see them settling it in this case, but it's a hugely interesting decision, and it's going to require like 100 more law reviews to sort it out, I think, before it's ready for solution.
I completely agree with Professor Alvaré. This is a very, very difficult question. And if the court were able to resolve it, leaving the law reviews aside, then we would also learn a lot about what standard applies, both in exercise and establishment, because some of these cases really come up at the play in the joints between the two rights, and they are often in conflict. I think the court has already come a very long way from 50 years ago, when the law took the position that money is fungible and that government aid to religious institutions didn't matter what it was earmarked for, but it would ultimately underwrite the religious activity, because the religious group would be saving money in one pot and have more money for expressly religious activities. We have, I think, softened that position in enormous deference to the importance of religious institutions and the various kinds of work that they do, educational, leisure, playgrounds, healthcare. And so that has also made the sorting out of conduct and status much more difficult than when we had a really bright line.
Thank you both. And the last question is again for the both of you. If the Supreme Court goes the full distance and discontinues the Smith test, what kind of test do you think might take its place? And separately, what kind of test do you think should take its place?
So I'll begin quickly. It would probably be, if they disavowed it, they'd go back to what people understand as the pre-Smith test, which would be the Religious Freedom Restoration Act stated test. If the state burdens religion, it doesn't have to be a mandatory religious act or belief. It just has to be a religious belief. It has to demonstrate a compelling state interest realized by least restrictive means. We've had some decades of RFRA now. The chaos that was feared if this kind of test was law has not materialized. For the students here, I really recommend summarizing the enormous quantity and variety of religious freedom cases and how we really have avoided sort of mass chaos. The court has proved itself able to judge this. Justice Ginsburg talked about this in her opinion about religious freedom in a prison, applying a variant on RFRA called the Religious Land Use and Institutionalized Person Act. And she said, no, we can manage the balance, and did. And I think that's what they would apply. I think Professor Ross and I might agree that some of the tensions in the court that were pre-Smith about, if you're going to have that deferential a standard to religion, are other things going to change in the court's application of it so they pull back a little? Are they going to not just apply what they did before? Is free exercise going to be easier to prove, but it's going to be harder, but it's going to be easier to make an establishment claim then? Like this play in the joints is going to be affected if they go back to a pre-Smith rationale where free exercise gets more protection.
Yeah, it's also true that the pre-Smith standard was only used for employment, unemployment benefits. It had not been generally applied. And so if we want to think of this as something that has a broader reach, then I think there would be some need to rebuild it, refine it, and provide more guidance about how it should be applied, and particularly if the underlying goal is to make it easier for people to get exemptions from generally applicable laws, and also to avoid having to make the factual inquiry into hostility. But I want to point out one thing that's very important in this whole field, that Justice Scalia underscored in Smith, that nothing stops the state from deciding to grant an exemption. The only question is whether the Constitution requires it. And even in Fulton, the Third Circuit begins by saying, you know, it's not up to us to say whether this is a good idea, or whether the city should make a compromise, or whether the Catholic services should make a compromise. We're only asked about what the law requires. And my personal inclination would be to urge people to behave more reasonably. That is not something the Supreme Court can issue as an order. But when I think about this as a recurrent and really tenacious problem, I think this problem of both sides digging in their heels is really something I would hope our society can do better at. I know that's not a law professor answer.
Thank you so much. That concludes all of our questions and our event. I want to give a huge thank you to Professor Ross and Professor Alvaré for joining us for this event. It's been one of our best attended events this semester. We'd love to have you both back. Thank you again, and we really appreciate you showing up today for us.
Thank you.
Thank you very much. Thanks, Professor Ross.
Thank
Bye-bye.
you.